We're the two teachers. Welcome to Citizen U.
LIVEstyle. Tonight, we're reviewing the courts.
Guys, you know how I love the courts, right? Who didn't want to be a lawyer when they went to college? Oh, Mr. Larson did.
Oh, boy.
But I guess I got borked. So what kind of questions do you have about...
Mr. Larson, what is borked?
Well, borked is one of those great moments where a proper name turned into a verb. Robert Bork, back in the 80s, wanted to be a Supreme Court justice. Ronald Reagan appointed who he thought was the most qualified.
He was very qualified.
Extremely qualified. But that Democratic Senate, remember the Senate confirms judicial appointments, said, he's too conservative for us. We don't want to reward Ronald Reagan with every pick on the Supreme Court. And so Robert Bork had to kind of slip back and say, I'm not going to get confirmed. He was rejected. He was borked.
Wow.
See. Yeah, so I'm slightly confused on the concept of stare decisis. Do you mind elaborating on that a little bit?
We have a common law system, which means our law is based on precedent. And some of our precedent goes back 500 years to the British courts. To have a law based on precedents, you have to have stare decisis. Stare decisis is the Latin term that means let it stand. It's evaluating Supreme Court decisions and court decisions based on judicial precedent, so that a judge today can go back 30 years ago and look at precedent to make sure that the decisions that are being made today are consistent with the decisions that were being made decades ago.
And the reason that's so important, Mr. Pandy, is we believe in equality under the law. If the Supreme Court made a decision differently every time a similar case came up, who would know what our law meant? But stare decisis guarantees you and I equality.
Is justice blind, though?
Boy.
Well, Mr. Larson just told you about Judge Robert Bork, that he was very conservative. And we know that because of their rulings in previous, if they were a federal judge before they became a Supreme Court judge, we know if a justice is liberal or if a justice is conservative. We also know that the process that we put justices through with the Senate confirmation process is extremely partisan. We know that Democrats want liberal justices on the Supreme Court. We know Republicans want conservatives. So no, justice isn't blind when it comes to the federal judiciary and the Supreme Court, because it is a very highly partisan process. Now, you talk to a judge about what influences their decision, and they're typically going to say the law, what the law says, what the intent of the law was, stare decisis, the facts of the case. They'll never admit that political opinion and their personal background actually shapes their judicial decisions.
Clearly, Mr. Victor, justice is blind is our ideal.
Right.
But we kind of know that's not always true because of these political factors. But we do know this, that we have these voting blocs. We know there are 5 conservatives on the current Supreme Court, and we can almost count on them to stick together. They vote together often. And we know we have a liberal bloc. And those 4 liberals can be counted on to act together. Do they follow public opinion? This is one of the great debates that we have in our class and in law schools and in lunch tables around the country. But as we say in class, the justices follow public opinion a little bit because they don't have enforcement power. Because they can't enforce their decisions, if the Supreme Court deviates too far from public opinion, we wouldn't follow. So in a very subtle way, as much as we say justice is blind, they follow public opinion to build consensus amongst the American people.
I see. Kind of moving on to a different topic, I've always been a little bit confused about the powers in the federal government and the powers in the states. So could you possibly explain to me the meaning of selective incorporation?
Well, one of our favorite words in this class, because selective incorporation clearly has given the United States Supreme Court more authority over the states. Remember, little by little, the Supreme Court applied the Bill of Rights to the states using the 14th Amendment's Due Process Clause. This is another example of that grand question we've been reviewing each and every night this week, that we know we need a stronger central government, but how much stronger? And selective incorporation has answered that by saying a little bit more stronger. It gives the Supreme Court the voice and the mouthpiece to rule on a whole lot more than it used to.
But your question also brings up the difference between federal courts and state courts.
Yes.
The idea that we have dual courts, that federal courts deal with federal laws like counterfeiting, piracy, bank robbery. and state courts deal with pretty much 95% of the crimes that occur out there. Now, the Supreme Court does have the power to hear an issue that came from the state courts if the constitutionality of the law is at question. Because the Supreme Court has what's called appellate jurisdiction. So they can review the decisions of lower federal courts, or the Supreme Court can review the decisions of state courts with their power of appellate jurisdiction.
We learn that in every Supreme Court case because the first issue they have to address is standing. Does the Supreme Court have jurisdiction in this case? If there's not a constitutional question, it'll stay in some other court.
So what is jurisdiction then?
Well, jurisdiction has to do with the right or the authority to hear a case. And again, in our federal system, we've given some jurisdiction to state courts, some jurisdiction to the federal courts, and in some cases, jurisdictions maybe to a military court or some other tribunal of sorts that arbitrates the law. Jurisdiction is one of those checks and balances on the American government.
It's a checks and balance because, remember, Congress gets to determine jurisdiction. Congress established the courts according to the Constitution, so they have the power to tell the federal courts what kind of cases they have the power to hear.
I like that jurisprudence word, not to be confused with jurisdiction, but jurisprudence is how do judges make up their minds? And we know there are really two options. Judicial restraint, that's a judge who says, I'm going to only apply the law as it is and defer to the elective institutions. Versus the judge who practices judicial activism who say, listen, I'm here to correct the mistakes in the law. I'm here to add in a little bit of my own opinion and my own experience. Today, activists tend to be more liberal, and those who practice restraint tend to be a little bit more conservative.
You know, we've been talking a lot about courts, but eventually it comes time for justices to make their decision. Why do justices issue written opinions?
Well,
it's a transparency. In the end, the court, even though their decision-making is secretive behind closed doors, the oral arguments take place in public. And then the Supreme Court has to make their opinions known because in the end, we operate in this country based on the rule of law, the idea that words matter. And so the Supreme Court doesn't have an army or a police force to carry out their words. They do rely on the public carrying it out. So the public needs to be able to read what they've written. Remember, it takes 5 justices to decide a majority on a case. It only takes 4 to hear a case, the rule of 4, the writ of certiorari. But in the end, it takes a majority of the 9, 5 to decide a case.
Let's review what those 4 opinion options are.
Please.
Majority opinion, concurring opinion, dissenting opinion, and a per curiam. Majority is what the decision is. A concurring opinion is when a judge is in the majority but has a different rationale. A dissenting opinion is in that minority. We don't agree with the opinion, and this is why. And a per curiam is an unsigned opinion. We're the 2 teachers, and you've been reviewing the courts. No fancy words.
No fancy suits.
Plain talk about issues you need to know.
Just in time.